In this video, we're going to talk about the negligence case of White and Jones. In White and Jones, a man had quarreled with his two daughters. He then tore up his original will and made a new will in which he left them nothing. A few months later, he made up with his daughters and decided to make a new will under which his two daughters would receive £9,000 each. He then instructed a solicitor, Jones, to draw up a new will on those terms. Unfortunately, after a few months have passed since that instruction, Jones still had not drawn up the will, and the man sadly passed away. Therefore, the daughters had received nothing from the man's estate. The daughters therefore sued the defendant's solicitor in negligence, arguing that Jones had owed them a duty to draw up the man's new will with reasonable care and skill. Now, it is important to bear in mind that the daughters had no contract with Jones. Indeed, they had not even interacted with each other at all. All of Jones' instructions had come from the man. Moreover, the loss that the two daughters had suffered was of a purely economic nature. And as we know, the law of negligence is extremely reluctant to find that someone owes another a duty of care to stop them from suffering pure economic loss. So how did the two daughters win their case? The House of Lords held by a bare majority that Jones did indeed owe the daughters a duty of care. Lord Goff's reasoning was based on practical justice. His lordship stated, "Here there is a lacuna in the law, in the sense that practical justice requires that a disappointed beneficiary should have a remedy against the testator's solicitor in circumstances in which neither the testator nor his estate has in law suffered a loss." Here the testator is a reference to the man. In these circumstances, there can be no injustice if the intended beneficiary has a remedy against the solicitor for the full amount, which he should have received under the will, this being no greater than the damage for which the solicitor could have been liable to the donor if the loss had occurred in his lifetime. Here the beneficiary, or the intended beneficiary, were the two daughters, and the donor, again, is the man. Lord Goff also made reference to Hedley Byrne, and held that the imposition of a duty of care in White and Jones could be justified by extending Hedley Byrne. He states, "This House should in cases such as these extend to the intended beneficiary a remedy under the Hedley Byrne principle, by holding that the assumption of responsibility by the solicitor towards his client should be held in law to extend to the intended beneficiary who may, as a result of the solicitor's negligence, be deprived of his or her intended legacy in circumstances in which neither the testator nor his estate will have a remedy against the solicitor." We've talked about Hedley Byrne in a separate video. However, in summary, the principle in Hedley Byrne states that a person may owe another a duty of care to not cause them pure economic loss if the person had assumed responsibility for it. Lord Browne-Wilkinson, who agreed with Lord Goff that a duty of care should be found here, had a different reasoning in mind. His lordship states that the solicitor who accepts instructions to draw a will knows that future economic welfare of the intended beneficiary is dependent upon his careful execution of the task. The solicitor, by accepting the instructions, has entered upon and therefore assumed responsibility for the task of procuring the execution of a skillfully drawn will, knowing that the beneficiary is wholly dependent upon his carefully carrying out his function. So we can see here that whilst Lord Goff and Lord Browne-Wilkinson both made reference to Hedley Byrne, Lord Goff had made more emphasis on the concept of practical justice and the need to close a hole in the law that had existed prior to White and Jones. Lord Browne-Wilkinson focused more on the potential impact that the solicitor's negligence may have on the future economic well-being of the intended beneficiaries. The principle in White and Jones has been applied by later courts. The principle has been neatly summarized by a textbook by McBride and Bagshaw, where they state that the principle in White and Jones applies where A wanted to confer a benefit on B, and C undertakes to assist A in conferring that benefit on B, but C's carelessness in assisting A ends up preventing A from conferring that benefit onto B. Here, A is the man, B were the two daughters, and C was obviously Jones, the solicitor. However, the finding that a duty of care existed in White and Jones was not gone unopposed. Lord Mustill dissented on the issue, stating that to hold that a duty exists, even prima facie, in such a situation would be to go far beyond anything so far contemplated by the law of negligence. In a situation like the present, the intended beneficiaries did not engage the solicitor, undertake to pay his fees, or tell him what to do. Having promised them nothing, he has broken no promise. As of now, despite Lord Mustill's dissent, White and Jones still remains good law and continues to govern the solicitor-client beneficiary relationship.